Can something as simple as adding your child's name to your house deed actually cost your family tens of thousands of dollars? Barbara thought she was protecting her son. Instead, she accidentally handed the IRS an extra $32,000 and didn't find out until 18 months after she passed away. She never got a warning letter, never got a phone call. The mistake was already permanent, buried in a piece of paperwork most people sign without a second thought. Could this happen to your family? By the end of this video, you'll know exactly how and exactly how to avoid it. Let's understand it through the story of Barbara. Barbara bought her house in 1985 for $68,000. By the time she turned 74, that same house was worth $420,000. She had one son, Mark, and one goal: make sure the house passed to him smoothly, without lawyers, without delays, without probate court. A friend at church told her the simplest fix was to just add Mark's name directly to the deed. No trust, no attorney fees, just a form from the county recorder's office. It seemed completely reasonable. Barbara went to the county recorder's office, filled out a quitclaim deed, and added Mark as a co-owner. Total cost? About $40 in filing fees. In her mind, the problem was solved. The house would now pass to Mark automatically. No probate, no waiting, no court. What Barbara didn't know is that she had just triggered two separate tax problems, one that showed up immediately and one that wouldn't show up until years later. The first problem appeared the very next tax season. By adding Mark to the deed, Barbara had legally given him half ownership of a $400,000 asset for free. That's considered a gift under IRS rules, and gifts above a certain yearly amount require a specific tax form to be filed, one Barbara had never heard of and never filed. No penalty arrived immediately, no letter. That silence made Barbara believe everything was fine. It wasn't. The second, much larger problem was still years away, hidden inside a tax rule almost nobody talks about. The rule is called the stepped-up basis. Here's what it means in plain English. When you inherit a house after someone passes away, the IRS resets its value to what the house is worth on the date of death. That new number becomes your starting point for taxes. It's called a step up, and it can eliminate decades of taxable gain. But when someone gives you part of a house while they're still alive, like Barbara did, there is no reset. You inherit their original purchase price instead. Here's exactly what that meant for Mark. Barbara bought the house for $68,000. When she passed away, it was worth $420,000. Because Mark owned half the house as a gift from Barbara, not as an inheritance, his half kept Barbara's original decades-old cost basis. When Mark eventually sold the house, he owed capital gains tax on the difference between that old 1985 price and the sale price for his half. If he had inherited that same half instead of receiving it as a gift, his cost basis would have reset to the date of death value, and that tax bill would have been dramatically smaller. The difference cost Mark roughly $32,000 in extra capital gains tax, money that a properly structured estate plan would have saved entirely. And the tax bill wasn't even the only risk. The moment Mark's name went on the deed, the house was also legally exposed to his creditors, his potential divorce, and his potential lawsuits, none of which Barbara ever intended. This mistake is incredibly common because it feels like the simple, low-cost option. No attorney, no trust paperwork, just a quick trip to the recorder's office. But simple and cheap aren't the same as smart. So what should homeowners do instead? There are several options that accomplish the same goal, avoiding probate, without the tax consequences. Option 1, a transfer on death deed, sometimes called a TOD deed or beneficiary deed. It's legal in most states. It lets your child inherit the house automatically when you pass away with a full stepped-up basis, while you keep full ownership and control while you're alive. Option 2, a revocable living trust. You transfer the house into the trust, name your child as a beneficiary, and the house passes to them outside of probate, again with the stepped-up basis intact. Option 3, and this matters most, before changing any deed, talk to an estate planning attorney or a CPA. Many offer flat-fee consultations for exactly this kind of question, and the cost is almost always smaller than the mistake. What you should avoid is adding anyone to your deed as a co-owner just to make things easier. It rarely does. It usually creates more paperwork, more tax exposure, and more legal risk than it solves. If you've already added a child to your deed, it's not necessarily too late. An attorney can review your options, which may include gifting strategies or restructuring ownership before it becomes a bigger problem. Mark eventually sold his mother's house 2 years after she passed away. He paid the unexpected capital gains bill, called his tax preparer confused about why it was so high, and then only learned the full story of how the deed had been set up. Barbara never meant to cost her son money. She was trying to make things easier. But a well-intentioned $40 shortcut ended up being one of the more expensive decisions in the family's history, simply because nobody explained the rule beforehand. Here's the key lesson. Adding a child directly to your house deed can eliminate the stepped-up basis tax benefit and expose the property to your child's creditors and legal risks. The biggest mistake was treating a deed change as a free, simple shortcut, instead of understanding it as a legal gift with real tax consequences. So before you make any changes to your own deed, remember this checklist. Don't add anyone to your deed without professional advice first. Ask an estate attorney about transfer on death deeds in your state. Consider whether a revocable living trust fits your situation. If you've already added someone to your deed, get it reviewed since it may be reversible. And talk to a CPA about the tax basis implications before making any transfer.